Good afternoon. Welcome to this celebration of Nelson Tebbe's outstanding book, Religious Freedom in an Egalitarian Age. The book covers a lot of ground. It starts with a discussion of methodology which he calls social coherence. It involves discussions of harm to others, fairness to others, freedom of association, and government when government speaks. He ultimately discusses a wide range of issues that are current, such as discrimination in public accommodations, employment discrimination, discrimination by public officials and whether their role matters and the extent to which it should, and government when it funds speech, for example, preferring religious speech over non-religious speech or vice versa, or both. My role here is primarily to introduce the speakers, which I intend to do. They will speak in the order in which I introduce them. They will speak for no more than 15 minutes. If they should speak for more than 15 minutes, I will stand up and I encourage you to applaud. After they have spoken, Nelson will speak for no more than 15 minutes. And then I will probably ask a question or make a comment and throw it open to the floor. So the speakers speak in this order. The first speaker is Micah Schwartzman, the Joseph W. Dorn Research Professor of Law at the University of Virginia Law School. The second speaker is Douglas NeJaime, a professor of law at the Yale Law School. Our final speaker before Nelson is Reva Siegel, the Nicholas D. Katzenbach Professor of Law at the Yale Law School. Thank you for coming. And then Nelson, of course, will speak.
Is this working? It should be. Can you hear me? Yeah? Okay. So, my name is Micah Schwartzman. I'm from the University of Virginia, and I'm honored to be here. I want to thank Aziz Rana for inviting me to this celebration of Nelson Tebbe's book. I should say I've been reading Nelson's work since I entered the legal academy. I guess it's been about 10 years or so. I taught his article, Excluding Religion, which some of you may have read, and if you haven't, you should, in my very first seminar on law and religion. And then we met at an annual Law and Religion Roundtable, which Nelson has been organizing for many years now. Over the last 5 or 6 years, along with my colleague Richard Schrager, Nelson and I have co-authored numerous articles, op-eds, and blog posts. We've worked together on something like a half dozen amicus briefs, including 2 that are currently before courts, one in a case called Barber versus Bryant, which argues for standing to challenge a law in Mississippi, HB 1523, which legalizes discrimination on the basis of traditional religious beliefs. We have a second brief in Masterpiece Cake Shop, which many of you will know about, a case in which we argue that the Free Exercise Clause of the First Amendment does not give a baker in Colorado the right to violate anti-discrimination laws. And we're very likely, I think, to have another amicus brief soon in litigation involving President Trump's travel ban, which is, I think, likely headed back up to the Supreme Court. But I wasn't invited here to talk about amicus briefs or all the work that I've done with Nelson, so I'm going to stop talking about myself in just a moment, or at least talking about my work with you. I was invited to talk about Nelson's book, but I want to plant a little flag on this amicus brief point and come back to it in a few minutes. So for now, let me offer a few observations about Nelson's book, which is a major contribution to the field of law and religion. I think the most important book published in the field since Christopher Eisgruber and Lawrence Sager's book, Religious Freedom and the Constitution. So the first thing I want to do is substantiate that claim, to argue that Nelson has made a major contribution. And the way to do that is to ask, well, what is it? What is the contribution of the book? The answer that I want to give here is that Nelson models a way of engaging in philosophical, moral, and legal argument about religious freedom. He starts with a methodological claim, which is that a good way to approach political and legal disagreements is by developing a set of principles and working out their implications for particular cases, going back and forth between our principles and our settled judgments about the cases to see whether we can achieve some coherence within our own views. This method is familiar in moral and political philosophy from the work of John Rawls, who argued that when we try to justify ourselves to those who disagree with us, we should seek what he called reflective equilibrium. That is, an equilibrium between our principles and our particular judgments about specific cases. We might not ever actually achieve such an equilibrium, but we can try to approximate one, and that is what I take Nelson to have at least attempted in his book. So the first contribution of the book is to provide an extended example of how someone reasoning about moral, political, and legal conflicts can try to resolve them in a principled way. Nelson shows that our judgments are not merely based on intuition, they're not ad hoc or arbitrary. We approach questions about religious freedom in a manner that's mediated by a set of principles, and we test those principles to see how they work in specific cases. Now, some of Nelson's critics want to reject this method, and they accuse him of being a Rawlsian, as if that were a pejorative. I think Nelson has the right response, which is to say, the method of reflective equilibrium is good stuff. You should try it sometime. You might be enlightened. More seriously, when Rawls put forward the idea of reflective equilibrium to justify his principles of justice, the main philosophical competitors were seen to be utilitarianism and intuitionism. In the field of law and religion, there aren't very many utilitarians. The legal equivalent, law and economics, hasn't exactly captured the imagination of scholars working on religious freedom. But we do have intuitionists, especially in the form of value pluralists, those who claim that it's impossible to resolve our conflicts through the use of reason, that is, by trying to justify our views, by going back and forth between general principles and more particular judgments in order to reach reasoned decisions. There are just conflicts between competing values, and we have no more than our brute intuition in order to resolve those conflicts. That's the challenge. I think Nelson's book is a response and indeed a challenge of its own for contemporary intuitionists. As with Rawls, it's not enough to challenge the method in abstraction. You have to deal with the arguments, and that's hard work. In a commentary on Rawls' A Theory of Justice, another political philosopher, prominent one, named Brian Barry, said that, quote, "From the first page to the last, it is simply crammed with arguments. This is literally true. In the final paragraph, we find Rawls firing arguments, bang, 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 for the last time." And for Barry, that was a high compliment, and I think it applies to Nelson's book too. There are arguments on every page, right through to the afterword, where Nelson closes by defending his method, and this is what he says. He says, quote, "Striving for outcomes that are backed by reasons can be more controversial in the short term, because the losers of a particular fight are not merely accommodated, but told they are on the wrong side of justice. But over time, the hope is that governing with reasons can promote a more lasting unity, not only because citizens who experience government regulation can understand why their arguments may have been rejected, but also because they know that arguments matter and someday may prevail. Arguments matter, and reasons matter. And if you want to argue with Nelson's method, then you have to make arguments that respond to his reasons, both for adopting his method and for adopting the principles and the judgments he thinks follow from the practice of it. There's no substitute for reason giving, at least not without going in for some sort of skepticism or dogmatism. Nelson's contribution is to lay down a challenge to both of those alternatives. How do we know that reasoned judgments are possible? And the answer is by providing them. And that's what Nelson does in his book. Here's a second observation, and this I mean to be a friendly suggestion. In the book, Nelson identifies 4 legal principles that he claims can help manage conflicts between religious freedom and the demands of equal citizenship. And the 4 principles are these. First, when the state accommodates religion, it has to avoid harm to others. Second, when the state accommodates religion, it has to act with fairness to others. It must treat religious minorities and non-believers in an even-handed way. Third, Nelson argues for a principle of freedom of association. And lastly, he argues for a principle of what he calls government non-endorsement. That is, that for the government to respect the equal citizenship of citizens, there must be limits on what it can say. It can't endorse religious messages any more than it can endorse racist or sexist ones. Nelson's clear that these 4 principles are not necessarily exhaustive, and so I want to suggest one more principle, which I think is implicit in the book and which I'm confident that Nelson endorses. And the principle is that when public officials, including judges, make political and legal decisions, they should use public reasons, that is, reasons that are accessible and at least in principle acceptable to others in virtue of their status as free and equal citizens. These are reasons that appeal to shared values in a democratic society, reasons that don't depend on any particular religious tradition or comprehensive philosophical doctrine. Now, I think Nelson accepts that principle because I wrote a short article with him about it. But I mention it because Nelson has written a book that's all about reasons and reason giving, and yet there is an implicit theory about the kind of reasons that are appropriate to give others when we're trying to resolve social and political conflicts. And that theory is going to be controversial, and at some point it has to be stated and defended, perhaps in another book. But Nelson, please don't write that book before I have a chance to do it, or at least let me author a chapter or 2 in yours. Here's a third observation. Nelson's book, like much of his scholarship, is continuous with his work as a public advocate and as a litigator. I mentioned earlier that I've worked with Nelson on some amicus briefs in cases involving some of the issues he discusses in his book, religious exemptions for companies that are opposed to contraception, or the rights of businesses to discriminate on religious grounds against gays and lesbians, or the power of the state to grant sweeping exemptions to discriminate on the basis of traditional moral views. Now, some critics have argued that it is inappropriate, indeed even a form of intellectual corruption, for legal academics to engage in public advocacy based on the views developed in their scholarship. Let me quote from a recent review of Nelson's book, in which one fellow legal academic wrote the following. He said, "More dangerous still are those legal academics committed to advocacy. They believe sincerely in the power of reason, even as they use their skills as advocates, writers of amicus briefs and authors of tweets and op-eds to ensure victory. In seeking to enforce their academic oughts, they move from the academy into the public arena, routinely working the refs in varied traditional and social media. Their rhetorical skills may win individual battles, but reason does not end wars. In the meantime, their advocacy contributes to the erosion of public and professional trust in the very quote-unquote reason in which they place their faith." That's the criticism. I think there's a lot to say about this response to Nelson's work, not least as applied to an area of law that has a long and distinguished tradition of lawyers who have also been among the finest scholars of their generation. Think about, in the present day, Douglas Laycock or Michael McConnell, who've both argued a number of Supreme Court cases, or Leo Peffer from an earlier generation. Here I'll just say, Nelson, I hope you'll forgive me for saying this, but you're not breaking the mold. You're right in it, right? I want to make 2 further points about this criticism of scholars who engage in public advocacy. The first is that what we do in the legal academy need not be radically divorced from the reasoning of citizens engaged in debates about the moral, social, and political debates of the moment. As academics, we often have more time than others to think about our views, to work them out systematically, to test them against objections, to make revisions, to engage in this process of trying to achieve some kind of reflective equilibrium. In a wonderful essay entitled "What Plato Would Allow," Jeremy Waldron once captured this view, which isn't to say that he agrees with it, but once captured this view with a line. He said, "Political theory is simply conscientious civic discussion without a deadline." And I think the same thing could be said about legal theory as well. If we reason and act with integrity, there doesn't have to be any sharp discontinuity between what we write in our books, like Nelson's, and what we put into our briefs or our op-eds or our Facebook or Twitter posts. In all of these, for us, scholarly, legal, and social, we may well be engaged in giving others reasons, that is, in the public justification of our views. Of course, as Waldron went on to argue, this approach to political and legal theorizing is not the only one that's available. When we do engage in theoretical inquiry, we shouldn't always have to answer the prescriptive question, so what's the payoff of your theory? What would you allow? There should be space for exploring ideas without worrying what we'll end up in our legal briefs or our op-eds or our tweets. There's nothing wrong with a division of labor in which some scholars do pure theory, some do applied work, and some go back and forth between these different domains of analysis and argument. But my second point is this. If it's dangerous or pernicious for scholars to engage openly in public debate on the basis of their understanding of the reasons available to them, then we are in deep trouble. Because the alternative is either to give up on scholarship, which is to say that a careful way of thinking about our normative reasons, to try to systematize and think about the implications of our values and our reasons. Or we have to give up on reasoning in public, or maybe the idea is we give up on both. But in an era of fake news, in a post-truth society full of, I'm just going to say this, full of political bullshit, and here I mean that in a kind of, I'm obliged to say in a kind of Frankfurtian sense, where people don't take reasons seriously, where they're not sincere about them, it can be tempting to give in to skepticism and cynicism about reasoning with our fellow citizens. But I think that's a conclusion we ought to resist, both because it is self-fulfilling and because it leads to a politics that is deeply illiberal, one in which we're governed not by reasons that we can understand, but by crass assertions of power. And the way to resist critics of reason giving and of public justification is to give reasons and to offer public justifications for our views, and then to invite others to respond in good faith. And that is exactly what Nelson does in his book, which is an exemplar of moral and legal reasoning, one which is worth defending and which I'm happy to be here to celebrate. Thank you.
So I want to thank Aziz for inviting me and Steve for coordinating us and this panel, and most importantly, I want to congratulate Nelson on his important and timely book. We're all better off for having Nelson engaging these questions, especially as they are, as Micah discussed, so important on the public stage right now. Nelson asks, how should we respond to conflicts between religious freedom and equality law? And he offers both methodological and substantive responses. In articulating and applying his methodology, which he terms social coherence, Nelson recognizes that legal reasoning is imbued with political and social dynamics. And so in my comments, I want to focus on how social context should inform understandings of the conflict between LGBT equality and religious objections, and I'll address that question specifically with respect to public accommodations, a subject to which Nelson devotes an entire chapter, and a subject currently before the U.S. Supreme Court in Masterpiece Cake Shop. So the court's considering whether to grant an exemption from Colorado's anti-discrimination law to a baker who refused to provide a wedding cake for a same-sex couple's wedding, and the baker has made constitutional First Amendment claims based on both free exercise and free speech. Nelson addresses Elaine photography at length, an earlier case that raised similar issues after a photographer and her husband, owners of Elaine Photography, refused to provide services to a same-sex couple having a commitment ceremony. And there, after the state courts denied their claims for exemption from New Mexico's anti-discrimination law, the U.S. Supreme Court denied cert. The principle against harm to others leads Nelson to reject exemptions for commercial businesses with objections to same-sex marriage. And his conclusions with respect to Elaine Photography apply with equal and perhaps greater force to Masterpiece Cake Shop. So first, Nelson considers access to goods and services, finding what he terms a harm to economic opportunity. He addresses the argument made most forcibly by Andy Koppelman that same-sex couples will easily find services elsewhere. And Nelson acknowledges that same-sex couples will experience increased search costs even if there are alternative providers, but to my mind, more importantly, he recognizes that in some parts of the country, in certain regions, same-sex couples will still face widespread discrimination that may make it difficult to actually procure goods and services. But for Nelson, it's not only tangible access that matters, but also equal standing. So Reva and I have been writing for several years now about conscience exemptions from laws protecting reproductive rights and LGBT equality. And in that work, we distinguish between material and dignitary harms. Material harms capture the tangible, practical effects of refusal, such as access to goods and services. Dignitary harms capture the ways in which refusals can demean and stigmatize those who are refused. In other words, the focus is on the social meaning of the refusals. So here I want to flesh out the meaning and relevance of dignitary harm, especially because it's become a real target for those supporting claims of exemption in this context. So I'm doing it by responding to two related arguments regarding dignitary harm made by religious conservatives and their advocates. First, that the refusal of service is for the lesbian or gay person mere hurt or offense. Second, that the Christian religious objector himself is situated in a way that would lead him to be stigmatized by the government's refusal to accommodate his objection. I'll take the first argument first. Many supporting Masterpiece Cake Shop have attempted to reconfigure the purpose of anti-discrimination law and public accommodations as solely concerned with questions of market access. So long as the consumer can get the cake from some other provider, then anti-discrimination law need not be concerned. Dignitary harm shouldn't count as a legal matter. So consider an influential amicus brief of 34 legal scholars filed in support of Masterpiece Cake Shop. The brief consistently places dignitary harm in quotes and uses it as equivalent to offense, asserting that the gravamen of litigation demanding redress for dignitary harm is that plaintiffs are offended by the tacit or open communication of another citizen's constitutionally protected beliefs regarding marriage. The state, the brief contends, cannot constitutionally provide redress for such offense. And Nelson persuasively argues that the harm experienced by the same-sex couple is not mere insult. Civil rights laws, he explains, quote, protect against social and political subordination. And when considering anti-discrimination law, Nelson notes that not only government but private actors can contribute to that phenomenon. For Nelson, dignitary harm relates to notions of second-class citizenship. Granting religious exemptions from anti-discrimination law, he argues, can reinforce differential standing and inflict unjustified indignity. Consistent with his method, Nelson finds support in other civil rights laws, explaining that anti-discrimination law doesn't allow exclusions of customers or clients on the basis of race, religion, or marital status, even when alternatives exist. So then the related second argument. Many supporting Masterpiece Cake Shop minimize the dignitary harm inflicted on LGBT people at the same time that they focus on the dignitary harm experienced by religious conservatives. And in some ways, these moves might appear to contradict one another, dismissing the harm on the LGBT side as, quote, mere insult, while at the same time equating the dignitary harm, quote, on both sides, to argue that operation of the anti-discrimination law stigmatizes the Christian baker. So consider again the brief of 34 legal scholars. Quote, Colorado surely could be described as inflicting a severe dignitary harm on Phillips, the baker, by officially disapproving of his fundamental convictions regarding marriage, and then graphically and forcibly communicating that disapproval by in effect conscripting him to use his creative talents to celebrate the very thing that his convictions disapprove, close quote. In another amicus brief, Ryan Anderson, one of the most vocal proponents of broad religious exemptions for opponents of same-sex marriage, argues, quote, this court should not allow Colorado to so demean and stigmatize conjugal marriage supporters. Consider also the brief filed by the Beckett Fund for Religious Liberty, the group that litigated Hobby Lobby and has been pushing for broad exemptions in both the LGBT and reproductive healthcare settings, quote, for seeking to live and pursue his occupation according to his religious understanding of marriage, Phillips has been demeaned, stigmatized, and made into an outlaw, or at least outcast in the eyes of the law, close quote. Speaking of equivalence, this passage quotes Obergefell versus Hodges, and specifically the court's description of the effects of same-sex marriage bans on gays and lesbians. Here, the language of denigration and stigma arises not to describe the plight of same-sex couples, but instead the lives of those with conventional religious beliefs. Nelson rejects this symmetry, concluding that religious traditionalists and members of protected classes are not positioned in exactly the same way with respect to the principle of equal citizenship. And he focuses on the meaning of the anti-discrimination mandate. arguing that civil rights laws, quote, do not single out religious traditionalists for special disfavor, but instead express disapproval of all discriminatory practices, whether religious or secular. The purpose and social meaning of equality law does not target religious people, nor alter their citizenship status. I agree with Nelson on both sets of claims, the meaning of LGBT dignitary harm and the rejection of claims of equivalence. And I want to elaborate and supplement these arguments by turning to social science on stigma and minority stress, clearly outside my own area of expertise, but relying on work of my colleagues at the Williams Institute at UCLA. On the first point, I want to focus on the baker's refusal as part of the systemic exclusion of lesbian and gay people, rather than, as Nelson may at times be read to suggest, a more isolated or idiosyncratic instance of discrimination that is nonetheless properly prohibited. And on the second point, I want to supplement Nelson's claim, which focuses on the meaning of civil rights laws, with attention to the substantive merits of the claim that religious traditionalists themselves are being stigmatized. So with the foundational work of Irving Goffman, we learned that stigma entails some degree of understanding of and concern for what others think, as well as internalization of the social norms to which one fails to conform. And Goffman's work inspired work by social scientists across a range of disciplines, and an important strand of this literature focuses on the context-specific nature of stigma. Stigma is a function of having an attribute that conveys a devalued social identity in a particular context. The contextual nature of stigma begs a question. So as scholars Jennifer Crocker, Brenda Major, and Claude Steele ask in an important work on stigma, if being stigmatized is a function of possessing an attribute that confers a devalued social identity in a particular context, is everyone potentially stigmatized in some context? And here, power becomes relevant to understandings of stigma. Answering their own question, Crocker, Major, and Steele offer a useful illustration. Although men may be devalued in some social contexts, in women's support groups, for example, in most contexts, in most cultures, being male is a valued social identity. And in many contexts, men are in positions of power over women. Hence, the experience of being devalued because of one's maleness is likely to be constrained in time, constrained to a few social contexts, and easily avoided by most men most of the time. The important work of Bruce Link and Joe Phelan refines understandings of stigma in ways that explicitly account for power. Quote, it takes power to stigmatize. Without reference to power, stigma becomes a very different and much broader concept that might be applied to lawyers, politicians, Wall Street investors, and white people. None of this is to argue that the stigmatization of Christians in the US cannot happen. Stigma is dynamic, culturally contingent, and responsive to changing values and attitudes. But Nelson teaches the importance of deciding cases in social contexts. And we're not living in a world in which those from the nation's largest religious denominations are stigmatized or demeaned, despite sincere invocation of vulnerability by religious objectors to LGBT equality. Indeed, as a large body of research teaches, stigma is a phenomenon with measurable quality of life impacts on stigmatized groups, which I'll get to. And this research at this point does not suggest that the process of stigmatization describes the experiences of Christians in the US. The case of LGBT people, in contrast, clearly fits within theoretical and empirical understandings of stigma. And here I want to rely on work on minority stress by my Williams Institute colleague, Alon Meyer. Meyer draws a distinction between general and minority stressors. Anyone can experience a general stressor. You get fired from a job, that's a general stressor. But gays and lesbians face a minority stressor when they're fired from a job because of their sexual orientation. As Meyer explains, minority stressors strain individuals who are in a disadvantaged social position because they require adaptation to an inhospitable social environment. And he breaks his minority stress model down into four distinct processes. First, chronic and acute prejudice events and conditions. Second, the expectation of such events and conditions and the vigilance required by that expectation. Third, internalization of social stigma, so internalized homophobia. And fourth, concealing or hiding one's gay or lesbian identity, the disfavored identity. What the minority stress model terms a prejudice event may be perpetrated by one person, but it carries a symbolic message of social disapproval. These events have a powerful impact precisely because they convey deep cultural meaning. So as Reva and I have argued in our work on conscience claims, the power to stigmatize derives from the fact that the refusal reflects a widely understood message about a contested sexual norm. The customer will immediately comprehend the social meaning that refusal expresses. So for instance, a bakery customer in Oregon reported that she had, quote, never felt so low in her life. as when the owner terminated the cake testing upon finding out that the woman was a lesbian. Similarly, when a lesbian couple was turned away by a wedding venue here in New York, near Albany, one of the women reported to the New York Division of Human Rights that while she had been, quote, feeling a lot more comfortable with herself since coming out, she experienced the refusal as, quote, a kind of blow to her coming out process. Even what many see as a minor event can evoke deep feelings of rejection and fear, seemingly disproportionate to the prejudice event that precipitated it. The event has symbolic meaning given the social context. So after Charlie Craig and David Mullins, the couple in Masterpiece Cake Shop, were refused service, Charlie left the bakery shaking, crying, embarrassed, and feeling like a failure before his mother, who witnessed the incident. Likewise, the lesbian couple turned away near Albany reported feeling shell-shocked and horrible. Critically, work on minority stress includes not only the act of rejection or discrimination, but also the expectation of fear of discrimination, which results in socialization in a rejecting and stigmatized society. In the public accommodation setting, rejection by a business may reproduce expectations of rejection and may lead gays and lesbians not to fully participate in the marketplace. So litigation, again, illustrates. In Arlene's Flowers, another famous public accommodations case, a florist refused to provide flowers for a same-sex couple's wedding. And the Washington Supreme Court observed that after the florist turned away the same-sex couple, the couple abandoned plans for a large 100-person wedding and instead married at home in front of 11 guests. Similarly, the lesbian couple turned away near Albany simply stopped looking for venues in the area. The consequences of prejudice and discrimination for stigmatized individuals are far-reaching. Practically, there's barriers to goods and services, and lack of access can have consequences on health and well-being, but more relevant to our discussion, there are significant consequences on psychological and physical health. As Meyer's work shows, stigma is a fundamental social cause of disease. Meyer and his colleagues link minority stress to bad outcomes in the LGBT population, higher rates of disease and mortality, higher risk of mental health issues and substance abuse issues, and adverse impacts on relationship quality and stability. So what does all this mean for law? Stigma interacts with law in significant ways. Law can be a vehicle for validating and perpetuating stigma. Law can also endeavor to prevent and redress the consequences of stigma. And research shows that LGBT people fare better in regions where social and legal conditions are more hospitable, suggesting that anti-discrimination law plays a role in reducing minority stress. So public accommodation laws are critical to LGBT people's social standing, which itself relates to outcomes with respect to health and well-being. So government is wise to enact anti-discrimination laws to reduce stigma experienced by LGBT people. And from this perspective, the intent of those engaged in discrimination doesn't matter to an assessment of whether the discrimination is wrongful. As anti-discrimination scholar Deborah Hellman argues, wrongful discrimination is the expression of denigration in a context in which that expression could lower the social standing of the person or group at whom it's directed. Discrimination, she asserts, is determined by action, not intention. And so the sincere religious objection of the business owner doesn't mediate the impact of the discrimination or the government's interest in eradicating such discrimination. Ultimately, attention to stigma and its consequences adds support to some of the most significant conclusions Nelson reaches with respect to public accommodations. First, the dignitary harm experienced by gays and lesbians refused service is real and significant, and it exists regardless of the availability of alternative providers, and it emerges even from events that to outsiders may seem minor. Second, government has an interest in preventing and redressing the dignitary harm through anti-discrimination law. Third, the dignitary harm arises in large part because of the social meaning of the refusal, and this social meaning, rather than the professed intentions of the discriminatory actor, is relevant to enforcement of the law. And fourth and finally, the discriminatory actor may feel harmed by the government's rejection of his request for an exemption from the anti-discrimination law, but this feeling of harm does not itself demonstrate that the discriminatory actor has been stigmatized or has experienced minority stress. Thank you.
Okay, is this working? Okay. So I wanted to begin by saying it's a lovely Friday afternoon and a testimony to community and affection for Nelson and all to see everyone convened, to thank Aziz for inviting us out, and to congratulate you on this book. the hotter our politics become, the more one has to be grateful for a book that models a certain form of community by reason and argument in the way that this book does in the middle of the debates that we're in the midst of. I am going to try to, I think I'm going to run short of my 15 minutes, and I've, in the course of mulling about the conversation, I even have questions about the question that I'm going to pose to Nelson at the end of my remarks. But I want to ask a question about the method of argument of the book. So, as I've observed, Nelson's book is staging an argument with religious conservatives about the possibilities of religious liberty law. And he engages with his those with whom he differs on the grounds, importantly, of their having skepticism about the possibilities of reason in this conversation. Engages with them as skeptics. And so the book is staged importantly as an argument about the possibilities of reason. That's an important ground of the book. And in using the method of social coherence, Nelson is showing us that he can demonstrate the possibilities of reason, not merely, and now I'm reading to you, that the claim that a reason for a solution is not merely stronger than reasons behind the alternatives, but rather that a solution coheres with other constitutional commitments in ways that the alternative does not. Even more strongly, that they may conclude that one outcome is demanded or determined by reasons, not just that it's supported by them. And coherence is what makes that kind of strong argument available as well. And it is no small thing in the midst of what is colloquially termed the culture wars to have Nelson's book available to us, showing how a series of religious liberty respecting, equality friendly outcomes are lucidly grounded in the ways that he shows us. And lines of argument in the book completely follow lines that Doug and I have, with some differences, pursued in our own work. Assuming all of this admiration, I'm going to observe something about the structure of argument in the book, which, depending on the context, it could be counted as a limitation, but I don't know that it's a limitation. I at least want to notice it as a feature of the way in which the book is argued and ask a question about it at the end of my observations. So one way of understanding this reflective equilibrium or the social coherence argument is that it's a principled elaboration of the status quo. That is, we are building out from settled arrangements and judgments that we have. We may be putting them, we may be interrogating them with our principles, but we're interrogating sets of commitments and decisions that are, and institutional arrangements around us. And there are lots of different ways in which Nelson observes this in the book. This is not like some surprise. He refers to setting out the, quote, broad outlines of a settlement that's been struck between existing civil rights law and religious freedom. That's one way of describing it in the book. Another way he puts it is that the search for coherence does not depend on a clean distinction between law and politics. On the contrary, it embraces the reality that our legal reasoning is shot through with political and social dynamics. So nothing I'm saying here is like a surprise or a gotcha. He's setting out this in the methodological portions of the book, but I'm going to just observe that there's a status quo bias to this way of proceeding. I'll also note that there's strategic reasons for the socially vulnerable to embrace existing legal authority, and that there are contexts and social arenas where it's especially urgent, but that this way of arguing may come at a price, or at least it's going to make certain kinds of arguments more audible than others. And that many Americans, whether mobilized on the right or on the left, may criticize much in the status quo. They want to appeal to values or defend modes of living together other than those that the status quo presently ratifies. And we're not going to hear those voices as clearly if we accept and reason from this mode of arguing. So in my very few minutes of comment, in order to put this question on the table to Nelson, I'm going to just sort of contrast a different way of looking at things, which I'll call a social insurgency model, just to stipulate that it's somewhere coming from the margins, not already as settled in our law and social arrangements. And just stipulating that it's going to be a way of understanding things that's less justified in terms of existing precedent and more concerned with trying to bring into being some other way of living together. And I'm going to focus on the public accommodations chapter that Doug has just been in, and just sketch some voices to the right and to the left, because I like hearing voices on the right as well as the left, so as to make the ground of argument sort of audible here. And just before I do this, I want to point out that Nelson also, just so that I'm not in the gotcha mode, I sort of read and reread his methods section. He observes of his own mode of argument. He points out that it is possible to defend broad conceptions of free exercise without skepticism, and social coherence itself is not designed to answer these arguments. Only substantive arguments can support, particularly, there's these passages but not elaborated. So part of my question has to do with when is one arguing in this mode, or what's the, but I'm going to just make these voices heard, and then we'll circle back. My goal here is to essentially set out, do we have the right way of arguing or do we have a particular way of arguing? That's my puzzle in reading and rereading these sections. So Steve Smith, who is his skeptic or key skeptic in the book, certainly has written pieces that are skeptical of the possibility of reasoned law in this area, but he's also an insurgent. That is to say, whether he's arguing from originalism or otherwise, he wants a much more robustly, religiously organized public life. And he is with mobilized, now conservatives, of either Catholic or evangelical Protestant stripe, who are looking to both have more religion in the public square, but also in the market. And that's why we have cases like Hobby Lobby and Masterpiece. These are not accidental. These are brought by a variety of actors and groups that are looking to resist or challenge existing public accommodations law. They're not only looking to distinguish who's covered by it, but to displace the idea of public accommodations, because they are looking to make possible the expression of religious life in market dealings in a way that the whole concept of public accommodations law is trying to resist. And I'm just going to read to you from an amicus brief in the Masterpiece case. These are organizations advancing the biblical principle that Christians must conduct themselves in their businesses in ways that honor and glorify Jesus. Like the petitioners, Masterpiece Cake Shop and Jack Phillips, these organizations and their members believe their Christian calling is not limited to ceremonial rites, but includes all of one's life. They do not see their lives as segmented into secular and religious compartments. Rather, they see their Christian calling as all-encompassing, indivisible, and under the lordship of Jesus. Their businesses or vocations are no exception to the biblical command, etc. So, and the same was true in the Hobby Lobby case. So these cases are being brought by groups who don't want to separate out the market from the space of religion. And I'm not going to read from the many other of the writings making these arguments. And so one could see in the space of the public accommodations chapter, it's not just a question of ought LGBT groups to be given the same treatment as other groups, but there's an effort to challenge the whole notion of a space in which persons who are engaged in market dealings are to abstract their religious commitments from their market dealings. The public accommodations chapter also is it's reporting, and again accurately, a sharp differentiation of the treatment of markets from the healthcare setting. And I raise this in the chapter because someone who's 5 minutes. Good, because I'm getting towards setting up my question. I raised this because I wanted to get my left interlocutor, my left social insurgent. So to make the argument in the public accommodations chapter, Nelson argues to distinguish between the case of public accommodations healthcare and to reject the conscience arguments in the healthcare setting. Why? Because there's much more capacious accommodation of conscience exemptions in provision of the healthcare setting where there's contraception, abortion, and other cases. In those areas, not only direct provision of medical services, but anyone involved in the provision of medical services can make complicity-based objections to dealings with patients, and there's no obligation to notify counsel or provide alternate services. That is to say, there's no attention to third-party harm in that setting in the way that there is in these other settings. So the argument here is to distinguish. A left critical feminist or potentially queer insurgent view of things could say this is a wrong approach as opposed to merely distinguish, right? And the question appears in looking at this mode of argument, to what extent does one move by the terrain as it's mapped in the existing settlement, in the terrain has been mapped by the existing settlement, to what extent does one again listen to these arguments that are potentially could be raised by those who are deeply critical of the existing settlement? And I've now put one from the right and one from the left on the table. I imagined someone from the gay rights community reading this book, and when I asked myself, would one accept this line of argument, I actually could hear answers that all said, it depends on what context. Am I writing a brief? Actually, it came to mind a conversation, we were on a phone call with persons writing a brief in the Barber case about whether one should just throw the abortion case under the bus or whether there was any obligation on the part of the lawyer advocate there to try to connect the two. And there are reasons why one would try not to distinguish. In the healthcare setting, there's coalition politics, there's questions also potentially of the gay rights community will face already has in the AIDS context, but will also face in ART context the need for access to healthcare. So there's a whole variety of reasons why one could reason that one cared as a matter of interest or principle to have different law in that setting. But in any event, what came to me in that thought was it all depended in what role I was asking myself that question, even as I was a gay rights advocate. It depends on if I was writing a law review article. When we were writing the law review article, we put the two cases together rather than distinguishing them. So here comes my question at the end of my comment. When I was thinking about the structure of the argument here, I was wondering whether this way of arguing was represented your best understanding in an acontextual, doesn't matter the audience, doesn't matter the setting kind of way, or whether this is in fact a mode of understanding the question that is best designed for guiding the evolution of law as expressed to legal decision makers in a way that's geared toward the elaboration of legal reasoning by judges. And I wasn't sure of the answer to that question. I actually wrote and rewrote the end of my comments, and part of the reason that I'm speaking orally now is because I found myself actually having written written myself in two different directions because literally uncertain of how to read you on that point. So I thought that would be a comment, or rather a question, that is a comment that is a question, and I'll stop there.
All right, well, thank you so much for coming. It's a total delight to be at an event like this, to participate in it. It's wonderful to see you all here, especially so many of my students. Thank you so much for coming. It's really heartwarming that you're here. I'm really delighted. Liz Flynn and Emily McFarland and Kara Conklin and Nicole Hanna and Aziz Rana all put a lot into organizing this event, and I want to thank them very deeply for all of their work. I also want to thank everyone, the speakers, for coming. Thank you so much for traveling long distances and hauling all the way to Ithaca to be at this event. I really appreciate it, and also for your generous comments. Obviously you've read the book carefully, and that takes generosity in itself. But then to think about it and offer comments in the spirit that you have is just a great gift to me, and I thank you and appreciate it very much. So I thought I might give just a very brief kind of summary of the argument of the book, just so you understand, kind of what I thought I was doing in the book, just in outline, because I know not everyone has had a chance to spend time with the book. And then to say a couple of things actually about this kind of tension between kind of normative construction and critical theory that have run through some of the comments, including the last one, and to give some thoughts on what I think the relationship is, and how, in that context, I would answer Reva's question. And then if I have time, I'll say some things about Masterpiece Cake Shop as well. As you've heard, the book takes as its subject the contemporary conflict between religious freedom and equality law. And it addresses that conflict in three sections, three parts. Or three steps. First, it argues against skeptics who believe that resolutions to these problems necessarily will be ad hoc, conclusory, or patternless. It contends that reasons can be given for decisions in this area of law, even if those decisions often will be overdetermined by interests and ideologies. And this is the method that some of the speakers have been referring to. Second, in the second part of the book, I contend that there are 4 principles. This is not an exclusive list, but I think these are principles that have emerged from actual debates that we've been having about these cases. And these principles can help us resolve some of the problems that we confront on the ground. The principles are, as you've heard, avoiding harm to others, or the third-party harm principle first. Second, fairness to others. That is, when we accommodate religious actors, we should not do that in a way that is unfair to or uneven-handed toward non-believers. Third, freedom of association. And fourth, what I call government non-endorsement. And then in the last part of the book, I use this method and I apply these principles to particular kinds of conflicts. The ones that I thought were most salient right now and were likely to be most salient in the future, but again, not an exclusive list. The first being public accommodations law. It turns out I was right about that, and now we have a Supreme Court case that's pending, Masterpiece Cake Shop, in that area. Second, employment discrimination. Third, public officials like Kim Davis, who claim religious reasons for wanting to be exempted from certain of their duties. And fourth, government funding, right? Decisions not to fund particular actors. And I try to sort of make arguments about how conflicts in these 4 areas can be resolved, given what I've said in parts 1 and 2. The method of social coherence structures the argument throughout. So that is, I start with particular judgments about which I have some confidence, or we have some confidence, judgments either about abstract principles or about particular precedents. It is very understandable that someone could ask, like, is there a status quo bias to this kind of method? And Reva Siegel has now asked that question, or offered it as a comment. I don't actually think so, for a variety of reasons, and I hope to argue against that idea. First of all, none of the principles that we start with are foundational, right? So they can all be examined in light of other kinds of commitments that we have and abstractions that we come to from on the basis of other judgments that we hold. Second, I think. And also the system is totally dynamic, right? So every element can be and should be re-examined in light of every other element, right? So no piece of this is foundationalist. Instead, it's totally dynamic. Second, I have trouble thinking about like how else would we think? Like if we're going to make normative arguments about how to resolve problems that are in front of us, we are going to use the cultural and normative tools that are like lying around, right? I don't think it's possible to sort of argue from first principles on lots of these kinds of questions. So this is a kind of less foundationalist, right? Less rooted kind of method of thinking about normative problems. And to the degree that people are making arguments, I think they are doing this implicitly, even if they're not really acknowledging it. And third, I would say that actually the point of this is not to defer to kind of received settlements on any of these questions in an unthinking way, but the point of the method is actually to stimulate re-examination of the kinds of inheritances that we have, right? In other words, to ask like, okay, you have this judgment that you think is well-founded or a principle that abstracts from that judgment. How well does it fit together with your other beliefs, and do you think that this thing can withstand scrutiny on the basis of that kind of method? From there, I seek solutions that fit together with, kind of our examined convictions. So to the degree that we can find outcomes that cohere, we can say that those outcomes are justified just in the sense that they're backed by reasons. I think this claim is actually quite modest. It's not that the method will generate one and only one outcome, nor that it will lead to agreement. Far from it. I try to be clear in the book that disagreement is a fixed feature of democratic politics and will remain that way in the future in this area as well as in many others. Instead, it's just that reasons can be given and that they can do some work, even if in many or most cases they're going to be overwhelmed by power politics and brute economics. Contingent social dynamics and political conditions play a huge role in this process. But this is not a faith in rationalism as sort of the key to agreement or social unity on these issues or any other. I think some people have misread me to be saying that. Arbitrariness, I think, within an individual worldview can, at least in principle or in theory, be eliminated. But disagreement among people who have different worldviews or are coming to different kinds of conclusions based on the normative and cultural resources that are lying around us will not go away, right? We should expect that to continue and embrace it as a healthy part of a vibrant democracy. At least two forms of disagreement we can expect to persist. First, claims that an argument that we disagree with is incoherent or unwarranted. That is, it cannot be squared, right, with other judgments that we and even the person who holds that view take to be supportable. But second, and this is far more common, disagreement can exist because the position that someone else is taking is incorrect though warranted, right? So they can put together a vision of the world that supports whatever position that they're taking, and then we just have reasonable disagreement, and we can't expect that to go away. It's a feature of our life that we're living with. But that worldview, right? And then we can resolve differences between reasonable perspectives either through legal procedures or else through politics. Sometimes we're just going to have to fight it out in the political sphere and try to convince one another. But even that thin and I think relatively ecumenical form of reasoning, like that method, a depiction of how we have fights with one another, is enough to defeat the very sort of most powerful forms or most extreme forms of skepticism that we're seeing in the public sphere right now. Because the approach admits the influence of a great many factors other than reasons, however, I think it's much closer in practice to the method of skeptics than it may first appear. And when it actually comes down to reasoning about cases, the methods that we deploy, I think, are quite similar. Anyway, using this method, I then support both the general principles that I set out in Part 2 and then also the more concrete recommendations in Part 3. Let me say something just about constructive versus critical theory and how it works in the book, because I think this has been of interest in reviews that the book has received and also in the comments today, and I do have some thoughts about it. I think the book's methodological argument does have implications for this tension between constructive and critical theory. Notice that the tension is bipartisan, right? So there's a sort of left liberal tension among progressives, but there's also a tension between conservatives who are insurgents, using Reva Siegel's term, and conservatives who are arguing in more conventional ways for outcomes that I might not necessarily support. So the tension itself is bipartisan. It divides scholars on both the left and the right. It's also cross-disciplinary, right? So the book draws not only on legal scholarship, but also on political theory and the academic study of religion. And in these two other fields as well, we see this kind of division, right, between critical and constructive work. It also depicts our political moment more generally. That is, right, as Micah Schwartzman pointed out, there are contemporary attacks on the very possibility of reason-giving or established factual argument. Finally, it touches on this relationship that Micah Schwartzman also mentioned between the academy and the profession, with some skeptics launching, quite strong and even harsh attacks on academics who engage in public debate, accusing them of leveraging principles and prestige in order to score wins in the arena of political advocacy. It's surprising and a little concerning how often you see that kind of argument today, that justifications do no work at all in legal decision making, and that seems to me both incorrect and quite dangerous. More promising, I think, is to imagine a kind of convergence between the most sophisticated forms of critical and constructive work on religion and governance, with each acknowledging some dependence on the other. And so in responses to critics and future work, I hope to sort of elaborate on how that might work. Let me say a couple of things about Masterpiece Cake Shop, just as kind of an illustration of some of this thinking. So the book opens, as has been noted, with a wedding vendor case. It's not the one that's before the Supreme Court, but it's the one that is very similar in some regards, and that is the Elaine photography case. In Masterpiece Cake Shop, a religious baker has refused to create a wedding cake for a same-sex couple, and the question is, how should we resolve that case? Start with the observations that public accommodations laws like Colorado's do not generally include religious accommodations. That's because exempting religious actors would frustrate the very purposes of these civil rights laws, namely, chiefly, I guess I should say, guaranteeing equal economic opportunity and protecting the full and equal citizenship status of all people. Interest groups are aligned on both sides of this high-profile case, and they will have an impact. But the arguments also matter, and the proof of that is just that the advocates on both sides feel the weight of those arguments, and they feel compelled to respond. If the arguments didn't matter at all, we wouldn't see attention to arguments, right? They would just let them sort of float in the atmosphere, but that's not what we're actually seeing in the way that the case is playing out. So Jack Phillips, who's the baker, points in particular to the fact that Colorado refused to take action against bakers who refused to create cakes that bore messages supporting traditional marriage. He points to those cases and says there's not a symmetry in the way that Colorado is approaching these two types of cases. When I refuse to bake a cake for a same-sex couple, Colorado says that's illegal. But when a progressive baker refuses to bake a cake that bears a message that supports traditional marriage only, citing scripture, Colorado doesn't take action against that baker, and that's a kind of lack of symmetry, right? So there's unfairness in the way that anti-discrimination law is being applied. Colorado, the state of Colorado, defends itself by saying there's no symmetry here. Our civil rights laws protect against discrimination that threatens structural injustice and stratified citizenship standing by targeted and protected classes. And people opposed to same-sex marriage does not constitute a suspect classification. Both religious and non-religious people fall into that class. And then Doug NeJaime in these comments today has offered elaboration support for this kind of response. So Phillips is disallowed from excluding LGBT citizens, just as he would be disallowed, as one scholar wrote recently, from excluding Muslim citizens because of their faith. Yet other bakers may refuse to produce cakes that denounce Islam as a false religion, even if they cite scripture in doing that. So civil rights laws take sides, but they do so only insofar as they protect full and equal citizenship standing, including when it's threatened by private actors. But they say nothing at all about exclusions that don't implicate structural injustice. I think the symmetry argument is deeply misleading. So status loss for majoritarian religious groups does not make them unequal citizens. That's not exactly the same thing. But my point here is not that one or another of these positions is correct. Rather, it's just that the arguments do matter, that Colorado is responding to the symmetry argument because it has persuasive power, even if politics and economics will do much or even more, as much or even more to determine the outcome of that particular case. In responding to Reva, I just want to very briefly say, I think that this is a method that works in all contexts. So I wouldn't say that it's just context specific, but I would say that it might work differently depending on the particular role that the scholar or advocate is occupying at a particular time. So maybe I should just leave it there, and I think we can say more about how those roles would implicate the method differently if we have time, because Aziz is waving at me now. It's time to stop.
Okay, here's where we're going from here. I'm giving Reva 52 seconds because she was exercised from the very beginning about something. And then I'm going to make a comment. Nelson gets to respond to neither of these. He can weave in responses to questions that you ask. So, Reva.
If I were to put on my democratic constitutionalism hat and we're thinking about constitutional arguments, it would depend on if I'm arguing before a court, if I'm arguing before Congress or a legislature, if I'm speaking to a social movement, and the ways in which I would understand what the Constitution requires would depend across those settings often, A. B, it's going to matter also if I'm speaking as an advocate and I'm thinking short term or I'm speaking long term. So part of me was just having that set of questions when I'm reading the book. And it could be, you could be saying to me now, yes, I'd still use the same method, but with different audiences and contexts, I might reason differently or balance it different. And I think I just used up my 52 seconds.
Okay, I have a few comments. First, I think one of the major contributions of the book is to show that Steve Smith, a quite distinguished, smart, well-read constitutional scholar, is wrong. And that whether or not you agree with the method of reflective equilibrium or you have a notion of a non-nihilistic view of critical theory, the deconstructionist methods of Steve Smith are seriously refuted by this book from page to page to page. The second comment I want to make is that the argument in favor of religious freedom is not just a conservative argument. The left is divided on this subject. Prior to Employment Division versus Smith, the left, the ACLU, was strongly in favor of religious freedom. The Religious Freedom Restoration Act was passed by liberals and conservatives, and there are still some of us left on the left who favor religious freedom in many of these contested cases. Third, Micah refers essentially to Steve Smith and refers to value pluralism. I just want to make the point that value pluralism is, in many of its forms, is consistent with moral objectivity. It simply recognizes that there are values that come into conflict that can create tragic choices. And that leads me to the wedding cake case or to the Elaine photography case. I think that Nelson makes things too easy on himself by having a harm to others standard that boils down to saying if it's more than negligible harm, then religious freedom will not be protected. There are some doctrinal disputes. He recognizes that there are exceptions in the doctrine to that principle and does a good job of trying to distinguish them unsuccessfully, in my view. I think that there is a failure in the book to recognize the extent to which the wedding cake case, well, you couldn't talk about the wedding cake case, it didn't exist. The Elaine photography case represents a tragic choice. Doug has done a very good job of explaining the harm that is done to gays, lesbians, etc. It is stigmatic harm. The notion of being turned away because of who you love is appalling. The denial of respect, the embarrassment that's associated with it, are all serious harms. But what the book doesn't develop is the extent to which forcing someone to violate their conscience, whether religious or non-religious, is a serious harm. And there's also material harm, because Elaine photography and Phillips in the wedding cake case will have to go out of business if they're going to continue to live their faith. And I sort of wonder what gay wedding participants would want Elaine to be photographing the wedding. There are, Doug mentions that there are alternatives some of the time, not all of the time. When there aren't alternatives, they ought to be forced to. The final point I would make is this. The law currently, and most evangelical Christians are not claiming that they should not be able to serve gay, lesbian, bisexual, LGBT customers. This is the question to Nelson. If you were in a legislature and Doug Laycock and Tom Berg came to you and said, we ought to have some kind of compromise here. Commercial vendors ought not to be able to discriminate against gay, lesbian, etc. customers. On the other hand, marriage is a central concern of theirs, and you could make this exception except in those circumstances where there are not other vendors away. As a legislator, would you be willing to engage in that compromise? And if not, would you concede that by failing to do so, you encourage the kind of crass associations of power and tribalism that currently plague our politics? Okay.